issues for employers and their foreign workers. And you can see from our agenda, there's quite a bit to cover. And first I'll go through, how do we check the rights of your foreign workers in Australia, just to make sure that you are hiring people with rights to work here. The second one is the Skilling Australia's Fund, and we'll go into more detail with that. And then what are your obligations as an approved sponsor if you are actually sponsoring foreign workers here, and then complying with the Fair Work Act. So we'll go through number one first, which is how do you check that a job applicant or a potential employee has the right to work in Australia. And this is quite important. As you can see, there are quite a number of penalties if you don't check that, or if you do actually employ illegal workers. And they range. So obviously 315,000 is really at the top end for a large corporate company. But if you're a smaller business or medium-sized business, you can be penalised and sort of fined for a range of a sum. And it can actually be considered a criminal offence in some situations that can warrant imprisonment sometimes, so it is important to be careful. So it is the responsibility of all Australian businesses and employers to check that whoever they employ are legal workers. Now, the Department of Immigration is really concerned with those employers and businesses that willfully sort of not comply with this requirement. And generally, your Australian citizens, permanent residents, New Zealand residents have full working rights here. And if you have if your workers are on a number of work visas, then they have rights to work here too. But a quick check can be done by going to VIVO, which is Visa Entitlement Verification Online Service on the Department of Immigration website. You need to create an IMI account for your business, and it's a very easy process to find that out. And the department's website has step-by-step guides to do that. You can then do some practical things. You can ask you can ask the employee for their visa details as well. They usually would have it, and they can email it to you if they have nothing to hide. The other thing to consider is how often, when you employ a foreign worker, how often should you conduct a check? Because often visa conditions change, and this is still the responsibility of the employer to make sure that they continue to conduct checks. So we say within 2 days of the visa expiring, if you are aware of that, or if the employee, if their circumstances change. Otherwise, every 3 months is actually quite prudent. So let's talk about the Skilling Australia's Fund, which is also known as the Nomination Training Contribution Charge. It came into effect on the 12th of August this year, 2018, and employers will need to pay a nomination contribution training charge for workers they nominate under temporary and permanent employer-sponsored visas. This charge is payable at time of lodging the nomination application. It is also known as the SAF levy. That money goes into the Skilling Australia's Fund, which is an initiative by the government to grow the number of apprenticeships and traineeships across Australia. So to clarify, this charge affects nomination applications made under subclass 482, 186 and 187, and those nominations made on or from 12th of August 2018. Any nomination applications made before this date is not subject to the NTCC. Now, the NTCC effectively replaces the previous training benchmarks. So, if you don't need to worry yourself about that anymore. And employers will not be simultaneously subject to this charge and existing training benchmarks that they might be obligated under. The good news is too that this charge is tax deductible as well. So as the PowerPoint displays, if your business turns over less than 10 million and you want to sponsor someone on a temporary visa, then it's $1,200 per year per worker. If it's over 10 million, then it's $1,800 per year per worker. And for permanent visas, it is a one-off fee. So under 10 million, it's 3,000 per worker, one-off fee. And then over 10 million, it's 5,000. So quite a substantial cost to the business. So if you're an approved business sponsor, what are your obligations as an employer? And there are quite a number of obligations, and I've just put the key ones in the PowerPoints. But I'll just run through them quite quickly. One is to cooperate with inspectors. So if a representative or an inspector from the Department of Immigration wants to enter your premises, interview anyone on your premises, or check that the actual person that you are sponsoring, employed, is actually doing the work, or things like that, then you need to give them access. You need to cooperate with them. They often will give you notice, but if there is any undue delays around your cooperation, that could be seen unfavorably on your part. The other thing too is, when you employ a foreign worker, you need to ensure that you employ them on terms and conditions that are equivalent to an Australian citizen or a permanent resident in Australia. So if you're employing a chef and as a foreign worker, then they essentially need to be on the same terms, benefits, responsibilities, work conditions, all that sort of stuff with your comparable worker, Australian worker. It's really important to keep records, and this includes any information relating to the sponsorship of the foreign worker, any communications with the Department of Home Affairs, and all your employment records pertaining to the sponsored worker. It's also important not to discriminate or participate in any discriminatory recruitment practices, and this is something that may need to be evidenced to the department if they ask you for it. So things like advertisements, your recruitment policies, your recruitment campaigns, those things need to be sort of retained if and when the department wants to see them. You do need to notify the department and provide information to them in certain events. You have 28 days notice to report on those changes, and they are things like, if the employment with the sponsored worker cease, if their work duties change, if there's a change in business structure, if the business is undergoing any insolvency or bankruptcy issues, those things need to be reported to the department. So then it's just ensure that the skilled worker, the foreign worker, participates in the actual nominated occupation. So if they start to do different activities, that could be a bit of an issue. And if anything associated with the removal of the employee, the sponsored employee, whether that is because their visa has expired or their circumstances have changed and they've decided that they need to depart the country, then it is the obligation of the employer to deal with any travel costs. They need to be reasonable, of course, and any debts or any costs incurred by the government in relation to that. So So the next part is, ensuring that when you hire a foreign worker, that you meet the obligations under the Fair Work Act. So it is important that your foreign worker, they receive the same benefits as any other employee in Australia. So that involves things like maximum weekly hours of work. They have entitlements to request flexible working arrangements, parental leave, any leave entitlements, public holidays, notice of any termination, redundancy pay, provision of the Fair Work Information Statement, and things like that. So it's really important that you meet your obligations under the Fair Work Act. Foreign workers aren't exempt from this, and that's something you need to consider. So thank you everyone for listening to this webinar. If you have any questions, there are 3 ways you can get in touch with us. You can type them in the webinar question box, or visit legalvision.com.au and use the live chat, or you can call us on 1300 544 755. Thanks so much, everyone. Have a great day.